Yeah, this is my second time in Miskolc. The last time it was almost 30 years ago. I came here by bicycle. Now I came here by car, so very advanced. But I was a student at that time, and now I'm a judge, so okay, I can afford it. Going back to my presentation. Impact of national law on the appointment of functions of honorary consuls. The principal normative act regulating consular activities in Poland is the Act of 25th June 2015, Consular Law, which was presented by Professor Piebiak and also by Professor Stasikowski. It came in force in 1st November 2015, so it's almost 10 years we deal with this act in Poland. And I would like to focus in my presentation, as the title you can see, on a specific group of officials of the sending state, namely honorary consuls. So the Polish act is consular law, and the international law, it is Vienna Convention on Consular Relations of 1963. And Chapter 3 of the convention, titled Provisions Concerning Honorary Consular Officers and Consular Posts headed by such officers, encompasses Article 58 to 68. The brevity of this regulation and the complete discretion regarding the use of this institution, because Article 68 states, each state is free to decide whether it will appoint or receive honorary consul officers. So, according to the convention, competences and the manner of their appointment by sending state, as well as the possibility of performing their functions in the receiving state, fall within the domain of national law. It is precisely this national law, Polish law, and I would like to focus on it in my address. As an introduction, let me offer a few general remarks on the institution itself and the origins of its formation. The institution of honorary consuls were known as proxenoi, citizens of another polis who were granted an honorary title by a city state. So it is ancient idea invented in ancient Greece. This title entailed the obligation to care for the citizens of the polis that had conferred the title and to represent its interests in the polis in which the proxenos resided. Today, the institution of honorary consul has a recognized place within the legal systems and operational practices of most countries, effectively complementing and enhancing in the interest of both the sending state and its citizens, as well as the receiving state, the functions performed by the professional consular corps. Currently, according to information published on the official website of the Polish government, Poland has appointed approximately 215 honorary consul. This figure indicates the growing popularity of the institution, as the number has nearly doubled over the last 2 decades. In 2005, there was 141 active honorary consuls. So this demonstrates that the institution is developing well in Poland. As previously mentioned, the regulation contained in the Vienna Convention on Consular Relations is succinct. One of its drawbacks is the phase to define the term consul, whether professional or honorary, despite a request made by the Portuguese delegate during the convention's drafting. As noted in the literature, the omission has left states with the discretion to define this institution themselves. However, as Professor Piebiak aptly pointed out, there can be no doubt that the states do not enjoy complete freedom in defining these institutions. While practice may vary with respect to specific solutions, particularly concerning honorary consular officers, it remains consistent with respect of the basic general principles relating to the institution. In this sense, one can speak a customary definition of this institution and thereby a conceptual definition. In Poland, 2015 consular law, honorary consuls are addressed in Part 5, titled Honorary Consuls, encompassing Article 120-137. According to Article 120, you can see here, an honorary consul of the Republic of Poland, hereinafter referred to as honorary consul, may be Polish citizens or foreign national permanently residing in the receiving state, who possesses a high degree of authority and offers a guarantee of conducting activities in accordance with the interests of the Republic of Poland. Article 121 adds, the following clauses of honorary consuls are established. 1. Honorary consul general, 2nd honorary consul, 3. honorary vice consul, and honorary consular agent. The latter provision clearly refers to the classification of professional consuls as described in both of the Convention and the Polish law. Pursuant to Article 314 of the Consular Law, whenever the Act refers to a consular office, it shall be understood to mean a consulate general, consulate, vice consulate, or consular agency, as well as a consular department or another organizational unit separated within the structure of a diplomatic mission of the Republic of Poland serving a consul. Ergo, regardless of their rank, an honorary consul has a consular office of a specific class, and the detailed scope of responsibilities assigned to them depends on the decision of the Minister of Foreign Affairs, which will be discussed further below. How is an honorary consul appointed? A partial answer is provided by Article 122 of the Act, which states the honorary consul is appointed by the Minister competent for foreign affairs for a term of 5 years upon the request of the head of the diplomatic mission in the Republic of Poland in the receiving state. The Minister competent for foreign affairs may dismiss the honorary consul before the end of the term referred to in paragraph 1. The combination of liberal requirements for the potential honorary consuls of the Republic of Poland, stipulated in Article 120 of the Act, which does not impose any educational, age, or financial criteria, does not prescribe any competitive procedure, and relies instead on subjective notions such as high authority and assurances of proper performance of duties alongside with the sole, albeit fundamental, requirement of permanent residence in the receiving state, with the appointment procedure described in Article 122, whereby the initiative must come from the head of the Polish diplomatic mission, leads to the conclusion that, formally speaking, the appointment of honorary consul is not a complex process. On the other hand, the generality of the regulation places significant responsibility on both parties involved, on the one recommending the appointment and the one making it, for the appropriateness of the decision. The ease of appointment is mirrored by the ease of dismissal provided by Article 122, paragraph 2, as the deliberate omission of dismissal criteria, appeal procedures, or even the obligation to justify the decision implies that the Minister of Foreign Affairs may remove an honorary consul at any time with immediate effect and without stating a reason. This regulation should be evaluated positively, in my opinion, as in the event of emergence of any negative circumstances concerning the person or activities of the honorary consul, immediate dismissal is generally appropriate to preserve the prestige of the sending state. Interest in or public discussion of the matter rarely serve the interests of the sending states. Naturally, the appointment of an honorary consul involves more than simply identifying a person residing in the receiving state who is willing and able to perform assigned tasks. A fundamental requirement typical in diplomatic and consular matters is the agreement or consent of the receiving state. This principle is expresses verbis in Article 125 of the Act, which provides, as you can see, the appointment of an honorary consul requires the consent of the receiving state. This traditional rule, in conjunction with Article 128.1, which states an honorary consul shall cease to perform consular functions if the receiving state withdraw its consent, implies that an honorary consul must at all times perform their duties in such a way as to maintain their position as a link between the sending state and its citizens and the receiving state. Any conduct deemed unacceptable by either party results of the immediate termination of the mission, since just as the sending states need not justify the dismissal of an honorary consul to any party, including the consul concerned. The receiving state is likewise not required to explain the withdrawal of the agreement. According to Article 123 of the consular law, when appointing an honorary consul, the minister competent for foreign affairs shall designate to the seat and consular district in which the honorary consul shall perform consular functions, specify the class of honorary consul, and determine the scope of the consular functions. The consular district in which the honorary consul performs their duties shall form part of the consular district of a professional consul. These provisions establish, pursuant to Article 126, the honorary consul is subordinate to the head of the diplomatic mission of the Republic of Poland in the receiving state. In matters relating to consular functions, the honorary consul is subordinate to the competent professional consul. The head of the diplomatic mission in the receiving state shall conduct an annual evaluation of the honorary consul, having obtained the opinion of the professional consul to whom the honorary consul is subordinate. These provisions establish a close relationship between the honorary consul and the sending state's diplomatic representation, not only at the time of appointment, when the head of the mission is required to evaluate the candidate's compliance with statutory requirements, ability to perform the assigned duties, for example, based on available financial resources, and the receiving state's reaction to the candidacy before submitting a request for the appointment to the Minister of Foreign Affairs, but also throughout the consul's term. This relationship is maintained through the professional subordination of the honorary consul to the head of mission and functional subordination to the professional consul. The annual evaluation prepared by the head of mission based on input from supervising professional consul provides a reliable assessment of the honorary consul's performance. As mentioned earlier, the ultimate consequence of a negative evaluation may be dismissal, but other actions are also possible depending on whether the evaluation is positive or negative. The next thing is the functions of an honorary consul. It is Article 129. The honorary consul shall assist the consul to whom they are subordinate in protecting the rights and the interests of the Republic of Poland and its citizens in the receiving states, fostering friendly relations and cooperation between Poland and the receiving state, strengthening these ties between the Republic of Poland and Polish citizens, persons of Polish origins, and persons identifying with the Polish nation, residing in the receiving states, developing and deepening economic, scientific, technical, and cultural cooperation between Poland and the receiving state, as well as promoting Polish economy, science, culture, and the Polish language, and providing consular assistance. Another important article is 130. I will not read it because lack of time, but you can see it here. And finally, Article 134. In justified cases, the Minister competent for foreign affairs may authorize the honorary consul upon their request to perform specific acts referred to Article 28.1. The provisions of Article 29 and 33 apply accordingly. So if you look at those articles, you can see that there are three groups of functions of honorary consul, Polish honorary consul. It may be categorized. First, traditional consular functions, typically performed by career consuls in which honorary consul provides support. This is Article 129. Second, functions involving cooperation with the diplomatic missions of the Republic of Poland in the receiving states. And the third one, which was presented very well by Professor Piebiak, notarial functions. Because as a former notary, he knows everything about notaries and functions of consul, also honorary consul, in this area. From a practical standpoint, the most significant functions are the traditional consular duties under Article 129. Here, the role of honorary consul is paramount. A particular feature of the Polish context is the presence of large and cohesive Polish diaspora communities. Individuals of Polish descent, often born abroad, sometimes with only ancestral ties to Poland, who speak the Polish language, identify as a part of Polish nation, and are engaged with Polish affairs. Many of these individuals hold Polish citizenship, either exclusively or in addition to the citizenship of their country of residence. Within the European Union, due to the generally equal treatment of citizens from all member states, it is increasingly common for Poles to reside in other member states for many years without applying for a local citizenship, and it's not necessary for everyday life. However, in cases of emergency, they may require consular assistance. When professional consuls cannot provide such assistance promptly, the honorary consul of the Republic of Poland may become the person who offers such support. Many Polish honorary consuls are drawn from the Polish diaspora and act as a natural bridges between Poland and the receiving country. They are familiar with language, culture, socioeconomic realities of both countries, enabling their work to be highly beneficial to all stakeholders. Often they are entrepreneurs, renowned academics, or artists who strengthen bilateral relations in their professional fields, whether economic, scientific, or cultural diplomacy, as covered by Article 129. In the realm of classic consular assistance, their involvement depends on their qualifications. In practice, if they lack legal education or experience, their support in such cases, such as detention or temporary arrest of Polish citizens, may be limited to notifying the professional consul. However, if they do have such experience, for example, they practice as lawyers, attorneys, they may be capable to directly providing appropriate assistance. Functions under Article 130 of the consular law are lesser external importance because they are primarily concerned coordination and planning with Poland's diplomatic missions, and those functions, namely the first and the second, are not controversial. The third one is very controversial, I mean notarial functions, but it was presented by Professor Piebiak, so I don't want to compete with my boss. He is the best in this area. This characterization of the influence of national law on the appointment and functions of honorary consul is not exhaustive, and it focuses on generally binding law, primarily consular law, and detailed operating procedures of Polish honorary consuls are specified in internal regulation, are often confidential directives issued by supervisory authorities, which is entirely natural. According to the Polish constitution, such acts are not binding on citizens and cannot impose obligation upon them. However, in a superior subordinate relationship, they are binding. In relation to an honorary consul of the Republic of Poland, the Minister of Foreign Affairs, the relevant diplomatic mission in the receiving states, and the supervising professional consul all occupy superior positions over the honorary consul. So a document titled Instructions for Honorary Consul, issued by the director of the Consular Department of the Ministry of Foreign Affairs, has a universal character, and the time frame, I have no time to discuss the detail of this document, but it is binding not for the citizens, but for the honorary consul, of course. And the last final point, I would like to raise concerns Article 4 of the Vienna Convention. You can see it here. From this article, it is clear that the Republic of Poland, as a receiving state, so I will try to briefly emphasize the different situation. So, working honorary consul in the Republic of Poland, the opposite. So, Poland, as a receiving state, enjoys broad discretion in determining the conditions under which it grants agreement to honorary consul wishing to operate on its territory. States party of the convention exercise the discretion in various ways. Some regulate the issue in their internal law, while others leave it to case-by-case decision made by often foreign ministries, based on uniform or varied criteria. Poland belongs to the group of states whose domestic law does not regulate this matter, which raises no constitutional doubts, since the issue concerns international relations and not citizens' rights or freedoms. Nonetheless, from a practical standpoint, it's inadvisable to establish rules which, when met by a state seeking to appoint an honorary consul in Polish territory, should result in the granting of the agreement, albeit not guaranteeing it. These rules are outlined in a document titled Guide for Diplomatic Missions, published annually by the Diplomatic Protocol of the Ministry of Foreign Affairs. According to this guide, a candidate for honorary consul should meet the following criteria. And you can see it. At least 25 years old, citizen of Poland or descending states or a third state, have permanent residence, enjoyed an unblemished reputation, have the financial situation or social standing necessary for independent and impartial performance of duty, which is very important because it's you don't have money from it, it's honorary, and not hold any public office in Poland, whether the appointment or election. It's very important not to have problems we discussed in December last conference in Warsaw. There shouldn't be any public officials, Polish public officials, be honorary consuls of the other states. So my time is finished. So I thank you all for being here and trying to catch my presentation. Thank you.